Hello everyone, today we introduce the law of the Germanic peoples during the migration era, more specifically of course the written one. We can study and chiefly the ones of the Goths and the Burgundians and the relation with Roman law, right? In these lands were, as you know, were some of the most Romanized, and these peoples basically adapted their um, legal systems accordingly and for the sake of government and maintaining, a point of reference could be for the Germans and the subject populations. These are all topics we discussed here and there. The migration era playlist is full actually of similar things. This is just a video about the history of law and looking a bit more closely at certain aspects of this process. So the law of the Germanic peoples between the say the end of the 4th century, beginning of the following, are characterized by this Germanic background of nomadism or semi-nomadism, say better, right, migration as it had happened, as these populations began to penetrate, as you know, the regions of the Roman Empire, and especially to settle in the western half. So each people was made up with stable polities, and specifically kingdoms, right, that had this fascinating ambiguity of being created, of course, as through the Fedus pact. So these peoples were technically settled in Roman lands to rule there on behalf of the Romans, but at the same time these peoples were naturally increasingly autonomous in the process. They had also to rule properly themselves, right? Because here, as we will see, the crucial point to remember here is the personality and the territoriality of law, right? These Germanic populations had been on the move, so also the concept of territorial rule was largely unknown to them, right? Not because they hadn't had a sedentary past. The Germans had been fundamentally sedentary for centuries, but the question was about the government, the rule, and the fact that specifically before the settlement, these populations hadn't had kings proper, right? They lived in this relatively egalitarian societies where all the various clans came together in public assembly and decided stuff together, but with a very low capacity of enforcement, a very low degree of authority. The only leaders they elected in a unitary sense was during war, and after war, everything came back as before, just because all the clans wanted to maintain their own autonomy, their own freedom at the end of the day, and therefore coming back to just the normal that they had previously been into. So, but there was no state proper. These were confederacies, but previously these had been tribes and composed by the clans, and their unity was through, in fact, mostly military matters. But for the rest, we see that even populations that had this evident collective names like the Alemanni or the Franks, etc., were there in fact were some of the most egalitarian, especially as the West Germans. Because they were less stratified, differently from the Goths, for example, that already had developed something more structured. But they called themselves like Alemanni, all the man, the Franks, the free. But in the face, let's say, in an international arena, but when they were home, basically all the tribal elements that composed these confederacies maintained their identity that was fundamentally more important than the collective one. But we know these things, we have seen them more than once. So, as we were saying, each people was made up of numerous clans which participated, in theory, equally in the common defense. And in this union, they had matured through, let's say, the same specific cultural tradition, which actually it's difficult to specify proper, also because these peoples had actually very homogeneous were quite homogeneous as politically and socially wise, right? They had characters in common that went beyond also the confederal boundaries, because in this way, but the core here was that they were fundamentally warlike societies, and their union derived from it. So within the society, which the clans constituted the fundamental cell, all these families were in equilibrium, right? That is, none of them, nor any of the free subjects who belonged to the same families, boasted a higher authority that legitimized it as the driving power of the people. In practice, this was already very different, right? If we see the first peoples that settle in the West, they are the Visigoths, and these are fundamentally already, they're the ones that launched with Alaric the concept of rex in Latin, properly the kingship. That was something otherwise unknown, right? The Romans called sometimes reges these kind of more, preeminent chieftains that objectively had that power, but technically the idea of kingship was something new, had matured exactly in this context, actually, in true Romanization mostly. But of course, even out there beyond the frontiers, these populations were not, these societies were not equal in the sense we mean. The migration era accelerated dramatically this process for the sake of unity of command. These peoples had to be cohesive and to have a single leader to, for the sake of unity of control and the unity of command. But and it was difficult to restore after these movements, this state of permanent warfare and threat of military annihilation being absorbed by other peoples or exterminated entirely. Certain imbalances within, so that certain clans were emerging, right? The freemen tendentially were losing importance. As we were saying before, different peoples had actually different levels of this stratification, right? The northern Germans were some of the least stratified. The Goths were some of the richest, even just before they actually entered the Roman boundaries, and therefore they had already powerful elites. These are things that are well, observable, for example, through archaeology, right? We can understand a lot whether, the freemen were more or less wealthy compared to the elites. There are interesting indicators that we've seen also in other videos recently, the comparison between the Longobards and Gepids. That could really make the difference between, victory and defeat, like in that case. But here, legally wise, the idea is that society had to survey, had to watch over, so that no clan, no individual would become too powerful to subjugate the others, right? Which, as we have seen in many videos, and this is not really my opinion, I made it a bit of a leitmotif of Schwerpunkt, but the idea is that it's not that this freedom, as we can interpret it, in modern terms, which is not even entirely, what in fact the deal of our actual rights is about, at this point in history, it's not necessarily a positive thing, right? There is a positive freedom that sounds more like liberty, and then a negative freedom that is literally to do whatever the heck you like, right? These clans were nothing but, mobsters, right? This is the point. They basically minded their own business. They didn't want anybody to touch their own thing. So that's why in the absence of a state, which didn't exist, they ruled themselves like that. And this balance was naturally functional also to that state of society, because, states are created just with a set of conditions. But let's say that you understand it for the sake of governability, even of pacification, this condition of, stateless society without a head is not just risky whether you were to go at war, and that's where the elected leader, but also is fundamentally unjust, or at least the needs that bring for this to happen are sometimes more pressing than the ones of having actually a just or pacified society. Now, this is quite important because in practice, you can imagine what the systems worked like. Now we'll see it with the feud. But it's obvious that as soon as these populations settled in more developed areas and began to cope, not just because of the contact with the Roman populations that, of course, were still, with their administrative and legal structures and standing, and that actually made most of the work at that point, also because the Germans were less than the rest of the population and were fundamentally diluted quite easily, at least in the most of the provinces. Of former provinces of the Western Roman Empire, they would try to create properly a state in sense of kingship and emanating these laws, written laws, because otherwise before everything was oral, right? And you can't expect in a stateless society where traditions are oral that these traditions are actually a matter. Of course, they were decided over and over. I mean, they didn't came as a standard pack of rules, but there was a settling over time, an increase of these provisions, etc. But they were fundamentally pacts between the various clans, and pretty much it. So there wasn't properly a fixed standard as you would imagine it in a modern context. Naturally, here there are important differences also in contemporary realities between civil law, common law, so that the latter basically functions in a sense like it was before, but with actually much greater restrictions and a much more stable and fixed point of reference than these societies could ever dream of. So that obviously comes through the necessity of any modern state to maintain a certain degree of homogeneity, of standard, of uniformity, legally wise, because otherwise you have a stateless and a lawless society, or at least the law of just of the stronger. Think about judicial duel, right? It's not really a great deal of justice, but if you wonder why it functioned like that in those societies, it is because very likely the strongest in arms at that point was more important for society as a whole, as the people, because it could save their skins in war, and these were, as we've seen, these occasions were very, very frequent, than actually being honest fundamentally with the others. Right? This is a very crude realization that it's better to have a dishonest individual that, however, with the others, that of course can challenge him and kill him, and the feuds and the eternal struggles between the competition between these clans was, in this sense, also weakness at the end of the day, right? But at the same time, it was more important to be a warrior at that point and to prove that you could crush your opponent, even in the, let's say, in the public arena, in the civil arena, because of your military virtue, than actually having a people that is internally pacified, but is exposed to enemy attacks and doesn't have powerful people that are able to defend them. And you understand that if if a person is wrong but manages to defeat in combat the person who has stood for its rights, let's call it in this way, this is also the same process through which the strongest, in that sense, will become more powerful. So it's a system that doesn't have an equilibrium with itself, and it's actually fueling, at the end of the day, as it happens in all these societies, the creation of powerful oligarchies, right, that at some point will take over, and however, from the standing on the base of their capacity that have earned also through that lawless but still political and military significant behavior, some more capacity to realize that the people does need a stronger authority that will eventually bring some of these clans to rise and to become, to produce kings of these populations, when also they eventually settled into the Roman lands. So only on the occasion, as if we've seen military conflicts, did the most skilled in arms take command of the people army, right? Because these are peoples in arms, remember it, and its articulations. The Romans designated these military leaders with terms of Decanus, that he was in charge of 10 soldiers, Centenarius at the head of 100 men, Millenarius under the command of 1,000 soldiers, Comes that he led a large group, and Dux that was this kind of leader at the top of a large part of society. Also, they reserved the title of Rex, as we were saying before, to those who assumed the unitary leadership of the people army. These terms in Latin, we've found them here and there when speaking of the military organization of certain Romano-Germanic peoples that naturally wrote in Latin at that point, especially as far as these statal dimensions were concerned, and that objectively reflected the organic of these armies. I mean, the Canos, the head of 10, right? These are various. They were. Yeah, we know that the Germanic military organization, as many others, were fundamentally based on a decimal system. Naturally, things in practice were very different because at the end of the day, a Comus or a Dux, it was even greater. But let's say, here we see there were also other the heads of the 50s or so on. But the important though is that this segmentation that Romans spotted and gave a name in this now are even paralleling certain of their own military units. Think about the century. And we're reflecting objectively the size in which the certain of the Germanic units had within the people, right? These were literally the families, right? The Decanus was the head of 10 people, but it was kind of a restricted family. Centenarius was the head of a consistent clan at that point. The Millenarius even more. And this is interesting because it's literally how they fought on the field. That is, they fought on the base of familiar ties, right? Not having a state that could impose them a strict discipline, they compensated in part by fighting alongside family, friends, kings, and so on. They were clientelar societies, naturally, that eventually were these terms in the eventual administration of the Romano-Germanic kingdoms was to match with not just this clans, this military units on the field, but in the administration, right? These started becoming kind of standardized titles that existed as such also in the Roman state. Think about the Comes, right, or the Dux. Think about that these federati received literally the same Roman military command, right? Think about when Theodoric received the command of the Illyricum, right, as Magister Militum. It was exactly as if he had been a Roman commander, administratively wise. So these were positions originally linked in Germanic society to particular moments, like to actual military capabilities, and which therefore did not become institutional yet for some time. Once, as we've seen, this organization was also produced. Let's say here the thing becomes blurred, but I mean the idea that fundamentally you see what's the problem. These were we talking about the Barbaricum, right, out there in Central Eastern Europe, Northern Europe? There was still a denomination like this. Like there were groups that more or less resemble each other. There were certain organics works on the base of actual functionalization based on cognitive human capacities. I mean, the fact that the company is normally 150 men size because it's the unit with the commanding officer on the field that can recognize all those 150 men that is a maximum human brain can do, basically, to know how they have to operate in combat, right? That's something pretty universal to human groups. But these terms naturally, and it could be that the clan became more or less powerful, between a war and another. So everything was fluid. There was nothing fixed. And as a consequence, not being their permanent administrative cadres and so on until the sanitarization, these titles weren't institutionalized, right? As we've seen at the end, once the conflict ended, all forms of command ceased, and the balance between families, right, the balance between subjects returned to mark in every respect the internal relations of the community. Pretty convenient. If you don't have a state, why would you even care, right? These were self-standing communities. Consider that the fare, think about the Longobards fare, right? That comes from far and from these travel communities, essentially, during migration. These were completely independent, also from a logistical point of view. The clans provided for their own food, they had their own cattle, they fought, as we've seen on the row, right? So that's truly what it means a stateless society, because there are no further bonds than the agreements between these clans. So in such a society, the source of law could not be other than custom, as you understand. The complex of uses that each people matured within it, and which constituted a significant part of the cultural tradition of which the people themselves were a staunch defender, because they felt it as a central element of their own identity. Remember that when we talk about these peoples, we say the Burgundians, the Visigoths, or also whatever they called them at the beginning. We are specifically talking of ethnicity as related to law, right? They used to say the only reason why you could be a part of that people is that you accepted their customs, right? Which doesn't, and we know that during the migration era, these populations integrated people from everywhere, right? Sarmatians, Huns, Romanized populations, Slavs, Turks. You can imagine all these elements that arrived mostly from the steppes, but to strike here, manpower was an important thing, right? Demographic resources was quite important. So there had to be naturally, there was need of these people from the outside, but a certain, obviously there was also a complementary need of political cohesion, and therefore these people had to accept the customs of the other populations. Also in here, it's interesting to know that these relations sometimes were looser. We've seen it recently. Which video was that? In which we were talking about, the Thuringians, right? That when the Longobards migrated in Italy, there was still these ethnic groups that remained kind of their own, right? We know that the Saxons entered Italy. The Longobards wanted to basically to make them become Longobards as well. They said hell no, and they came back to Germany. We find, however, in Italy still certain islands of Swabians, of Thuringians, of which also Agilulf, we were saying before in that video, in fact, was an exponent, member. And so even the actual cohesion here, it didn't have an actual uniformity as we can imagine it in modern terms, simply because there was the authority didn't quite exist as such, right? As a higher one, even when it actually starts forming, still the control on the whole society was looser. Many of these people, the problem of the Romano-Germanic kingdoms, as we've seen in many occasions, was that they succeeded in migrating, in settling, finding this land, but the problem is that as soon as they settled, all the higher nobility basically scattered along the country. They seized land, possessions, fortresses, and so on, and they started becoming a problem. Very few Germanic peoples actually had a monarchic control, and this. Well, let's not digress, but it naturally had a political institutional impact. We've seen it it's the case of Visigothic Spain, for example, very fascinating in this regard, because it was a very Romanized, if not the most Romanized actually, of the Romano-Germanic kingdoms, and in fact this is reflected by the fact that the nobility took on essentially Roman costumes rather than Germanic ones, whereas in a place you would think like it was most Romanized, like Italy, the Longobards maintain always a Germanic law, and not only, but they manage even to create a public authority, right? More compact kingdom. They was less socially stratified. The monarchy managed to maintain an order. Could talk about the Merovingians that create literally a dynastic power, but also in there, basically, the unity of the kingdom fragments after a while. You can think about the Anglo-Saxons that create this kind of, I don't know how many, 60, 70 small kingdoms. That was also, and you can imagine how low was at that point, how these legal productions could be different at some point. However, nor in this picture could custom proper be an act of, say, empire of a higher authority, comparable to the leges or the constitutiones of the Roman Empire. Nobody could issue them as such, because even in the most powerful Romano-Germanic kingdoms, most centralized, the king was not a lawmaker, but just a formalizer of customs that the assembly of free people had to approve, as much as his own election, for example, because here the dynastic idea was something also pretty distant from their mindset. So, of course, such an authority like the Roman imperial one was unknown to the Germanic peoples, and the additions, clarifications, completions of the uses transmitted orally from generation to generation could only take place through a decision adopted by all the families that made up the people, all the clans. Ideally, because naturally it was full of clans, but some of them didn't count anything, some were more powerful, right? And when in fact the need was felt to integrate, complete, clarify the content of traditionally followed usages, the popular assembly composed of the exponents of the clans met, took a decision on the matter that all those present undertook to respect, right? This is important because technically it was the entire people that had to accept that, because otherwise, and that was the deal here. Actually, we haven't addressed, maybe before a bit hinted to it, but the metus hostilis, the idea that as soon as you were that political cohesion, political agreement, right, accepting a law or not, means to confer greater or smaller cohesion and therefore stability and force to the people in their international arena, right? If the assembly reunites, meets, and half of the people wants to do something, the other wants to do something else, it means de facto in this picture that this kingdom, whatever they actually think it like to be, is split in half. And if the neighbors know this, of course they know they can face not the united people, but a weaker one. So these assemblies were an extremely important place, meeting place. Naturally, the more we go back in time, and it's they are also very exemplificative of also how the eventual political institutional changes of these kingdoms eventually was. What was the council doing, right? Where was the council? Was there even? How was it integrated into the system, right? In Visigothic Spain, basically came to coincide with the Episcopal Council, the one of Toledo, which were all representatives of the Romano-Visigothic nobility. In other, in France, basically the Merovingians, they have it, but they fundamentally doesn't work per the mind. It's really about the actual power that the individual dynasts have, or their clienteles, right? In Longobard Italy, you have obviously everything is done in the name of the Longobard people reunited in the Gyretings. That is the Gyren text that is always, it's the only passage through which a law can be issued. But we know that, of course, it's not that all the Longobards actually participated in it. That the king was, taking, the upper hand, or at least having an ever heavier importance in the decision making, but also in the law making in the first place, because this also intertwines on how were laws issued, like who could respect and who could not. There are societies where everything remains largely private, in a sense. Others in which instead there is a public authority that can really issue, that has the means, the infrastructures, the personnel, the capacity to issue that. So it's not to be so, it's important to point out. So the absence of this institutionally appointed authority to guide the community also marked the forms of justice that characterized the legal order of the Germanic peoples. These forms, let's say, were expressed first of all in the feud, right? The revenge, the vendetta, the family that had suffered damage in the people who made it up or in the things that it owned had the right to return damage of equal magnitude to the offender's family. Right? This makes you understand also how individuals were fundamentally in function of the family, of the clan, right? How the clan was this literally, when you think of the mob, right? It's literally the thing, right? It's the vendetta, it's their own business, it's the fact that everything happens within the clan, and it's that represented in a smaller scale this people on their own, right? That's how jealous they are of their own freedom, and in this way of the feud, this is pretty famous. I mean, these peoples were always troubled and crossed by this deep conflict at the end of the day. In competition was at least in a juridical sense, the alteration of the social equilibrium caused by the damage, right? I kill you, I've caused your clan damage. So your clan is expected in the first place to react and to compensate the situation by killing another one of equal value, by the way, because people do not have the same value. This is the interesting thing, right? The ideal freedom here, it doesn't quite exist at all, right? You can't kill a person that is more powerful than you. That what's the value of that person? How much the clan will ransom it, right? And how this altogether means in that society that it's usually having a good if they have more money, they will ransom in more, so they are also more money here. Money is a big word, but of course more assets, let's call it in this way, more property. Well, they're also more powerful, so they're people you have to watch out for. So they won't kill you they will kill you, maybe someone else in your clan as well. So, however, the idea is that the feud could resolve in the absence of the police, right, of a justice system, of the alteration of the social equilibrium caused by the damage, right? And this could, in that context, it was actually an immediate and direct remedy, right? What should have been done? You're being damaged. There's no other authority is gonna help you. You have to make justice by yourself. So, to the full satisfaction not only of the family that had suffered the damage itself, but also of the others who could not accept undue individual advantages. The feud was partially replaced, or in any case supplemented, by the so-called compositio in Latin. And here we are when things start becoming a bit more civil, in the sense that rather than killing someone else, you could simply pay a sum or transferring assets by the family of the offender to the advantage of that of the offended. This is, incidentally, what starts happening when a king appears, right? Because as a king, you don't want your country to be ravaged by people who want to kill each other because of revenge. You're certain with your own authority that there's been a damage. This still has ambiguous, overlappings, intersections with this kind of public/private de facto understanding of the situation. But instead of killing the other, you compose with this it could be money as well at the time, yes, but it was mostly also other forms of wealth, and had the same objective as the feud, rebalancing, let's say, the conditions of the two families in this way, right? It's a bit the same thing, because as we've seen with the vertical, you basically you have a price as a human being, right? So yeah, instead of killing you, also the church was starting to have its own say in this matter. Just pay the value of that man, and it was considered, right, actually a fair deal. So feud and compositio were instruments of rapid justice. Thanks to them, the social fracture was quickly recomposed, and the people army could in a short time regain the internal cohesion that was indispensable to efficiently face the possible clashes with the opposing peoples, in which he had, the possibly encounter in their migrations, right? So the aim of a rapid settlement of disputes also characterized other forms of Germanic justice. For example, in the event that the author of the damage was not certain, and you can imagine here is who is that decides that, or whoever was accused of it, if it professed innocence, or two subjects boasted the same right. These are all things that are interestingly documented in the in papers of the time and so on. The solution of the dispute was entrusted to the judgment of God, right? To the ordeal, which is also not a great choice, right? Unless even just in Christian terms, justice doesn't belong to this world, right? But still, the idea is that in these barely Christianized societies, still largely pagan, of course, there was a lot of, and there would keep being also in Christian times for that matter, as a legacy of that, but not only. The idea that magic pervaded the world, and that therefore certain tests of this kind, such as through chance, gambling, and so on, would take on an important meaning also as an expression of universal power into that matter. You understand it's not a great idea, but the thing happened like this: at the popular assembly or at one of the military camps, the accused was subjected to a physical test and declared innocent if he passed it. He was guilty otherwise. In another case, with two contendants, these were invited to engage in a duel, the so-called judicial duel, the winner which was proclaimed the holder of the disputed right. It was what we were saying before, right? And this, as also you understand, is not a great thing. This is fascinating also because the people were not, there is all this gradual modification of the original custom. Originally, at least the two contendants were expected to actually fight in person themselves. Probably already since ever, another member of the clan could fight in another's stead. But it happened over time that there were also professional duel champions who would be hired to settle these matters and paid for that. And it's fascinating because in certain laws you find things like it's forbidden, for example, for these guys to assume certain substances like drugs or stuff, to actually to improve their strength or something like that. But you understand this is not a fair thing. And we even find in Germanic laws, there was a beautiful one from Liutprand that was issuing another set of laws, but in the introduction he stated explicitly that albeit he found judicial duel to be unfair, unjust, right? Also, there was a Christian concern in that, not just most even just one, but and you understand even there the path of civilization. He was acknowledging that he, as a king, couldn't issue that law because the Longobards people didn't care about it. They wanted to continue using that because it was such a rooted custom that it would have been useless to legiferate against it, to forbid it. This is fascinating because it shows, even in a moment in which that monarchy had some, good capacity of issuing laws and having them respected, still there is the problem of, can this law be fully applicated? Like, will people obey that? He was stating no. And that's a deep realization if you think about it. But there is still the trace of the attempt of doing something better, something that works more justly. So the judge of the trial, or of the duel, in this case, were first the gods, then God, so that the judgment could be final on divine basis, let's call it in this way. So since there, in that sense, there could be no judge superior to God. Originally, this was the God, of course, and in Christian terms, it basically remained even part like that, the military one, right? The military glory of the skies, as we like to term it in Schwerpunkt, that in that sense was all one with the military, the warlike ethos of these peoples. That is to say, if the only moral system that existed at the time was objectively, the stronger rules, well, it's obvious that problems of justice can be solved through the sword, because it's literally the only moral parameter that you know. Then, as we were saying, things start changing that regard as well, with sedentarization, states emerging, and so on. So the assembly or the court meeting with the military leaders carried out a function that was not decision making, but in this sense merely declarative, as we have understood. They limited themselves to declaring the outcome of the ordeal. Right? There was a sacral value, of course, and these people were essentially the most worthy to speak that out, to officialize it. Also because everything was oral, so literally it was said. It had juridical value. If you know Germanic law, you know that. This also went on. It was true also in other laws, in other peoples. If you state that publicly, you have witnesses. That constitutes a legal. It's still true today, because of course everything we say has specific legal. We are responsible of our own actions, of our own words still. And of course, over time, this function became a bit more than declarative. Kings literally became judges of the matter themselves. But originally, everything was done as an outcome to quickly close the dispute and restore social cohesion. That was the primal necessity of the society. When you were out there in the Barbaricum, threatened by surrounding peoples who were going to crush you, the most important thing was to settle this matter immediately, because any internal weakness could be fatal for the entire population. When you settled down in early medieval Europe, where political things, there weren't particular threats or invasions, because actually early medieval times were pretty, were more turmoils at a local level than especially in Western Europe, right? It's not an enormous thing. For centuries, it didn't happen much, right? So it was a matter more of regulating local matter, actual justice. So it was not a matter of recomposing the unity of the people, where you didn't even control great parts of the same kingdom, because it was in the hands of other private people. But as far as your land was concerned, you wanted to make justice, and you also started to have the means to impose yourself on freemen, because you were, your clientele as a nobleman were becoming more powerful. If you were a king, you had some of the greatest, so you had the force to impose. And this is an important civilized principle. I mean, the idea that you must confer actual deterrent power to authority to make it work, because otherwise there would be no authority, and everything would be actually even worse. So this set of costumes matured among each people was considered a fundamental part of the cultural heritage of this, a heritage that could not be extended to those who were not part of the same people. These laws were frequently issued, sometimes with the recalling of the origins of the same people, of the, if you want, the mythology standing behind it, so religious sacral values of sorts. So these customs made the people, as we were saying before. Ethnicity here equates to law. So that when several peoples found themselves, as a consequence, living together in the same territory, right, the principle of the personality of law was valid, by virtue of which each of these people followed the customs of their own tradition. A principle, therefore, opposite to that of the territoriality of law that is enforced in contemporary legal systems, according to which anyone who is in a state physically on the territory of that state, other than that of which he is a citizen, is required to follow the law of the state of which he is a guest, not his own. And the principle of personality of law seems to have characterized the first Germanic settlements in the regions of the Western Roman Empire. In that phase, that is, which historiography designates as the first wave, let's say, of Germanic invasions, a phase marked by the arrival of, if you want, small, contained at least Germanic communities, which settled also in limited areas of the conquered regions, that were organized themselves according to the form of their tradition, while they left the rest of the territory to the defeated Roman population. This is typical in a way. Usually the Germans settled in those strategic areas that would maintain also the military character of the community, and that were incidentally, in fact, also the least Romanized. Not always, like, there is always an in-between of this, but the same migrations naturally were changing the political and strategical balance of the place, and it was difficult to enforce their power over the richest and most populated Roman areas that, at the end of the day, were the ones with which it was better to ally and to form familial ties that would happen. That's why we speak of Romano-Germanic kingdoms, and that could provide also important assets for the construction of a state. It was otherwise still standing at that point, most of the times, and so with all the clerics, all the written culture, simply the bureaucratic skills, the capacity of ruling this more complex systems that gradually the Germanic rulers acquired themselves. So here we're talking, as we were saying before, mostly of the most Romanized Germanic peoples, and also the ones that structured themselves more like along the pattern of a kingdom proper. We're speaking of the Visigoths and the Burgundians that belonged to that first wave. So, as we know, the Visigothic dominion began at the end of the beginning of the 5th century and involved, in a first phase, which lasted until the 6th century, Aquitaine was the initial center, and the other western regions of Gaul, with Toulouse as in theory, the capital. It's interesting that the Germans settled in cities as proper, right? And especially in the most Romanized lands, they start ruling from there, right? Because that was the center of administration previously. And famously, after the defeat suffered in 507 by the Franks led by Clovis, the Visigoths would lose control of the regions of Gaul and moved beyond the Pyrenees, reaching the point of occupying the entire Iberian Peninsula, where they elected instead Toledo as their main center. The Burgundians, on their part, settled in the region of the Geneva Lake in the mid-5th century and subsequently extended their conquest to the territories of the Rhône and the Saône. It's worth noticing that the Burgundians had properly been settled by the Romans after it had been defeated on the Rhine. That's also where all the Nibelungen lead the history of, they are with Ezio and Attila, and all the stuff actually takes place. In these areas, there was actually not particularly Romanized. I mean, certain centers were, think about Vienne, the Gallia Lugdunensis, basically, but also in areas like the Sepaulia were fundamentally frontier areas. But from there, they expand after they after the Western Roman authority collapses. But still, these are in the surroundings. They find importantly Romanized areas, right? The southern Gaul was fundamentally one of the most deeply Romanized provinces of the empire, and within these kingdoms, the Roman communities, in fact, retained their previous law. These people, this is the crucial thing we'll talk about now, and also in the future a bit more. That is, the Germans came to rule on basically a wide majority, an overwhelming majority of Roman population, right? And in terms of the personality of law, that is a big deal, because those people are Romans proper, also in the eye of the Germans, from their own juridical standard, for their same juridical standards. There were other issues like most of the Romans were Catholics, while the Germans were usually Arians or pagans de facto. So that would create further attritions, but it was never so dramatic as one would think. And the problem, though, with the Roman population that made up the bulk of labor labor strength, right, of the working force, was that it was no longer disciplined, right? Their doctrine was no longer nourished by the primary sources of doctrine, right? We're talking of the imperial jurisprudence and legislation, and at that point, in those territories had, being legally in place. So, as a consequence, the same Roman populace ended up adapting spontaneously, right? That is, in a customary way, to the evolution of society and to present itself as a primary component of tradition proper of the subjugated population, right? A law that, however, found a firm and certain point in the text of the Codex Theodosianus, that had been the major collection of imperial legislation promulgated by Emperor Theodosius in 438. That would remain fundamentally, at least in part, and not completely, as you understand, the Justinian Reconquest with the Codex Iuris Civilis. That was technically the completion of the Theodosian Code as well, but it was basically the Theodosian Code expanded, so remained the main point of reference for what Roman law had been today. You know that Roman law had been very fluid, like up to the late Empire. The Theodosian Code corresponded to this principle of perpetua sanctio, for which now it was the idea that the Roman Empire would have crystallized, would have remained always identical and perfect and universally organized, so that no change would ever occur. So these Roman populations had gotten used to that, albeit Roman authority, the Roman state, was evaporating from those areas, so even the capacity of actually enforcing law had ceased. So these Roman populations had began to create their own customary Roman law, right? That they had also modified compared to the previous Theodosian Code, and that now met with the Germanic law of the conquerors. And this is where things start getting very interesting. So, as we were saying before, the conquest of the western regions of the empire significantly changed the living conditions of the Germanic communities that from semi-nomadic became sedentary and found themselves facing the unprecedented problems of a territorial defense. Right, this thing had never happened. Right, even if they had been sedentaries back in the day, they inhabited areas where resources didn't allow much more than some development. That's also why all that kind of warlike emphasis on society itself, because there were no major infrastructure. It was all in the hands, literally, of the political cohesion we were saying before. This is true always, right? It's not that fortresses made the politics of peoples, not even the case of the Romans. But they relied much more heavily on this otherwise more unstable political and social picture that had therefore to be founded just on the collective agreement on the, at least in moments of military threat. And here the Germans were exposed to something that invested them immediately at the first moment of the settlement, such as the division and distribution of the lands, right? Think about the hospitalitas that was literally, even the Roman Empire was institutionalized for the federati that were given like one third, 1/4 of the Roman land. That in practice didn't even mean they actually seized 1/3 of 1/4 of the extensional surface. They just mostly got the revenues from the annona, from the local taxes, that served already under the Romans for maintaining the local army, and which now was substituted by the Germanic army, by the people army, which was pretty much the same, as you understand. Also, Romans and Germans in terms of military organization have become, more similar in time. Also, the affirmation of private land domain alongside the collective one. The cultivation of relationships with Roman communities and others, let's say in this way, imagine society starting to mix. I mean, how many Germanic men and Roman women started a new life in that moment. Consequently, traditional customs had to adapt to the new social reality and at the same time open up to the influence of Roman law. By sheer contact, by sheer osmosis, I mean, the overwhelming majority of society, we're talking of percentages of Germans that are literally from 1 to 3%. That is already a pretty high number compared to the rest of the population. So you leave basically as 2 or 3 people amongst 100 that have a different legal system for you. How do you think it's going to go? Right, you are of course adapting to that yourself, albeit you also bring something in. This is what we will see, and this is maybe not so evident in the case of the Visigoths and the Burgundians, exactly because these are the peoples who had the most Romanized legal systems. Were we to speak of speaking about the Franks, speaking about the Longobards, the Anglo-Saxons, I would say obviously that those. They properly Germanized from a cultural, from an ethical point of view, meant literally in a juridical sense, as we were saying before, the local lands. These in southern Gaul and in Spain instead were the Roman law maintained the greatest, I would say, the upper hand, even within the same Germanic law in a sense, in practice, because at the end of the day they all got Romanized, right? The fact that you have namely and formally a Germanic law doesn't mean that you actually do not introduce certain certain features that are actually proper of Romanization. I mean, just the fact that you actually write them down and in Latin, says something, right? And naturally, the Roman nobility, the bureaucrats, the clerks still existed there, worked in the palaces, in the cities, heavily contributed to this. They made it happen, right? And were requested and were rewarded in this sense. And consequently, these customs had to adapt to the new social reality, and this would happen by virtue of the continuous relationship with the defeated population. An evolution of customs ensued that did not always occur uniformly, right? Not always clearly and definitely. And this is where most of also the interesting studies and about these topics are, because we're not dramatically documented about those societies, but we have certain codes that sometimes we even have the difficulty of attributing to the actual people that issued them, because they also shared them sometimes, right? There were certain laws that were maybe issued in Visigothic Spain were to be found in Ostrogothic Italy, or apparently, and we don't know even here how this is the problem in the history of law. How did they work, right? Why were they issued? Who did respect them? The mechanics are not clear, so that requires a great comparative analysis. Here we can't do just for the sake. I'm not an expert, first of all, but also for the sake of time, and still it's somewhat foggy. And these are, by the way, in Southern Europe, the best documented realities. So that tells you how difficult it is altogether, also for other peoples. But what we clearly see is that there was a need to define these laws for the sake of governability, of course. This need was, first of all, as you have understood, felt by the Visigoths, who, in a popular assembly in 475, defined a text of the customs enforced in a text called the Lex Visigothorum, also known as Codex Euricianus. So the the law of the Visigoths and the Eurician code. The Visigoth was a Gothic king, and the king Euricus, who had urged writing, the writing of the customs, and had promoted the meeting of the assembly itself. So you have to imagine even the summoning of these assemblies was not something that happened from a day to another. These peoples now were, as we've seen, they are sedentarized, so they're scattered all over a territory that in previous times, the Germans were like a unique people there. So when they moved, when they did everything together, were a concentrated populace. Now they're scattered all over, and they're also deeply now growing and, close with the local population, their own clienteles and so on. So it becomes really a very complicated thing just to meet, to create the assembly, to make it of universal value, and it becomes a very important political testing capacity, let's say, for the monarchy. The same initiative was taken in the Burgundian kingdom by the King Gundobald. A popular assembly whose dating is placed between 480 and 501, we're not sure, approved the drafting of the Lex Burgundionum, the law of the Burgundians, also known as Lex Gundobada, right? Because of Gundobad, as the king who had issued it. And the writing of the juridical norms did not, however, stop at these collections as well, right? In the Visigothic kingdom, in 506, during the reign of Alaric II, the Lex Romana Visigothorum, or Breviarium Alaricianum, or Breviarium Alarici, was approved. It was a large collection that brings together the leges, the laws taken from the Codex Theodosianus, post-Theodosian constitutions, and fragments of works by Roman jurists, especially Gaius and Paul. This is fascinating because you understand what this is. This is, from the title, Lex Romana Visigothorum. It means the Roman law of the Visigoths. Right? It means that here the Visigoths are introducing this Roman elements from the Theodosian code, from post-Theodosian constitutions, and even fragments from previous jurists like as Gaius Paulus. And can you imagine what for? Obviously, to come to regulate Roman society as well within their own territory. Probably, and with a Roman law, obviously, remember that's demographic unbalance. Those are the white majority. You have to make them work, and they already work by themselves because they have their laws. They all have their society. They always have their business, their craft. They already work like that, right? So you don't need to erase those customs. You need to integrate them, if anything, in yours. And probably before that date, even in the Burgundian kingdom, a collection of Roman norms was defined, substantially similar to the Visigothic one, although less elaborate, and here took the name of the Lex Romana Burgundionum. So the same thing, the Burgundian law, the Roman law of the Burgundians. So this regulatory complex has traditionally been read by the juridical historiography as a clear expression of the principle of the personality of law. Right? The Lex Visigothorum and the Lex Burgundionum would have contained only the law of the two Germanic peoples, and therefore would have been directed exclusively to the latter, while the Lex Romana Visigothorum and the Lex Romana Burgundionum would have defined the rules followed by only the Roman communities in the two kingdoms, and to which communities it would have been destined. But as we've seen now, there is something that doesn't work. Why just creating actually a law for the Germans and exclusively for them? Here we should have, and another just for the Romans. This was the old red of the idea that when the Germans arrived, they just subjugated everybody. The Romans were just slaves. Which now something that I believe is at least 4 or 5 generations old and completely debunked. Right, so I already spoiled you the thing before, actually. But here, for the sake of explaining how it's actually been, right, the process of understanding this, you can speak of Zollmer, for example, that began to understand that things were different regarding in his studies about the Lex Visigotorum in the Monumenta Germaniae Historica. So Zollmer believed that the rules of this collection were applied both in disputes between the Goths and in those between Goths and Romans, and that since the beginning of their dominion in Gaul, the Goths had known a progressive evolution of their ancient uses due to the influence of Roman law. In this regard, it should be noted that the rules of the Gothic text followed the traditional formulation of Germanic customs, governing the numerous variegated individual situations in which subjects could find themselves in juridically relevant relationships. Right? I don't know if you ever studied Germanic laws, but they're kind of, they're simple in juridical, form. But they're very insightful, actually, and never confused, especially if you study history of law written by modernists or contemporaries, that this phase is depicted like the Stone Age, right? Everything is so simple and stupid. No, if whoever studied Middle Ages accurately knows that these laws were of dramatic intelligence and that they worked and they kept working for a long time. So they're very, very worth learning. But just for making you understand, this is basically all individual laws, right? It's not like in Roman law that you have all the various categories and institutions, and it's something extremely complex, sophisticated. These are objectively just a list of, if this happens, this has to happen, right? And there's dispositive in that way. And the rules, in fact, open with expressions in Latin such as si quis, e qui, that means, if vu, or those vu, or quando quis, et simile. So in the evenience of, right, in the condition this happens in some way. And Zollmer's idea would then lead to the conclusion that the same imposition had been followed by the Roman discipline, right? Would have limited itself just to modifying, integrating, enriching the discipline of subjective cases defined by the ancient Gothic tradition, without ever arriving at overcoming the case a low perspective and defining broader theoretical categories. Now, Zollmer's thesis was resumed and deepened by Cortese, who found that the Lex Visigotorum and the Lex Romana Visigotorum contain, quote, substantially homogeneous material, and consequently claimed that they addressed both ethnic communities of the kingdom. They then would have not had a personal character like in the ancient Germanic tradition, but rather a territorial one, like the Roman law. Do you understand what this means, right? Because the Lex Visigotorum, in addition to the objective of specifying the customs followed by the two ethnic groups, would also have had that of transforming the Goths literally into citizens subjected to a regime of written law like the one of the Romans, like the Romans themselves. The second, the Lex Romana Visigotorum, instead, would have been decided both to favor the training of jurists of the Visigothic kingdom, and above all to offer, that were largely also of Roman background, and above all to offer a clear text of the law which was the basis as a matrix of the uses defined in the first collection in the Lex Visigotorum, and which could therefore integrate the gaps and illuminate their interpretation, which is a hell of a compliment to Visigothic leadership. This character with two collections expressed, according to Cortese, the particular political condition of the kingdom, that the Visigoths themselves still considered part of the Roman Empire, and hell as they did, right? The Visigoths were the ones that probably pushed the most for actually imitating the Roman Empire, also in imperial forms for themselves, right? At least as a properly as a kingdom, and not much of a like a dynasty like the Merovingians that actually did the most things. So eventually Cortese's thesis was shared also by other authors like Conte, according to whom the belief of the Visigoth kings of being part of the Roman Empire would find confirmation in the fact that they required the Roman emperor to grant the title of a high bureaucratic office, that of the Patricius Purpureus, right? So literally, the purpurian, the imperial patrician, that was in this sense kind of not the emperor, of course, but something that would be his vicar in some form. In that context, these were still federati, right? Remember, the Visigoths, even up to the 60s of the 5th century, were dramatically close to be reabsorbed and being, resettled somewhere else. Think about Majorianus, and those were some of the most dramatically Romanized lands, and so you understand that the aim of the Visigothic leadership was to fundamentally homogenize the Visigothic and Roman law in a way that could transition towards the latter most, because it was more functional. And this was still a time, by the way, because also the dating here matters. Eventually things changed after a while. When the late antique, political and social system, we're still standing, right? We're still fundamentally functional, and nobody had quite perceived the idea that these lands were not Roman anymore, they didn't belong to the empire anymore. However, the latter interpretation of just Roman, this request seemed to have had a different motivation, right? The one of the Patricius Purpureus, that was linked above all to the need of the Visigothic kings to obtain from a universally accredited authority as superior as the imperial one, some sort of legitimation of their leadership, imposition of the people army. Also because as we were saying, the Visigothic kings, well, maybe at this time they weren't faring that badly, but still, they wanted to have an extra confirmation within their land of their power. Why? Because that role of guide, of leadership, as we've seen, was not institutionalized in the Germanic tradition. The Visigothic king would not claim, here I become basically a quasi-imperial ruler of the gods. Even if the Roman subjects would have said, why not? The Germanic nobility at that point was said, no, you can't, because we are now in charge of our own stuff. You can't. We have to remain. This is you see, it's not much because they cared very much about their own custom. It's because they cared very much about their own assets, right? And they didn't want a central power to take over, because otherwise, still these kings came from the same nobility, and in there all the struggle that is also famous in the Visigothic world of between the Arians and the Catholics for conversion, for what the local Romano-Visigothic nobility wanted to do or didn't want to do, and this oscillation with the kings that wanted to kind of homogenize everything, and these guys didn't, and they kind of appealed to the older traditions, but it was pragmatically political in nature as a struggle. And from this position that they demanded to Constantinople, the Visigoths, after settling in the western regions, the Goths would have obtained also particularly extensive land patrimony that would have thus recognized by imperial power and being legitimized as stable and indisputable. So this was actually a very clever thing to do. It was still heading towards the homogenization of the local rule. If you wanted a further integration in the Roman system, doesn't tell necessarily much about the need of blending the two laws, but it was still happening, and we know that it was at the end of the day how the thing happened. They let it happen in a way. They didn't have means to obstacle it more than much. But still, beyond the political motivation, Cortese also suggests that there was a sort of reiteration of a significant rapprochement between the Gothic people and the Roman communities, right? That for the Gothic kingdom would have not overcome the rigid principle of personality law and the formation of customs to both ethnic groups. Not only because Cortese says that these customs would be characterized not so much by the review of Roman norms by the ancient customs of the Germanic people, as Zoima believed, but on the contrary by the grafting of uses of Gothic origin into a base linked to the traditional Roman juridical system, that those uses would have shaped in a significant way. Hence the use of an official Roman normative collection, even if drafted in a reduced form compared to the original, as an indispensable reference text for the interpretation of the established practices. That is to say, the Romans were, they at least read this thing, they knew the thing, how they went. So they had to be showed this contents as well, deriving from the Germanic law. So in this reading, the Theodosian Code, or rather the Breviarium Alaricanum, would have offered the certain discipline of a right valid for the community of the kingdom as the main matrix of the customs in force, right? A right that could, for good reason, be as qualified as common as it was present in every community of the Visigothic territory as a foundation of the uses followed by those followed. Right, and the conclusions on the Visigothic juridical collections, again according to Cortese, must also be extended to those of the Burgundian kingdom. That it was thought to be done the same, which is, at least these are probably some of the most, sophisticated historiographical acquisitions, and they show how fundamentally the need to blend in a way or another wasn't unavoidable, right? It was fundamentally deriving from the necessity of trying to control both of the sides in ways that we can't see clearly, because these are just hypotheses in a way, but that maintain, especially at this point, a bit more. Actually, what I didn't explain before is the following. At this point, the Visigothic rule was surely marked by a less compromising character, right? Of course, things ended well, right? We know at the end of the day, the Visigoths converted to Catholicism, like all others, because once again, there was no possibility. But it's obvious that the first settlement was, of course, marked by the idea that these were the conquerors and they had to still discipline in part the subjects in that way. But at the same time, we see as a spin-off, let's say, the necessity, the capacity of starting to speak in a language that could be understood by the both of them. In fact, that now there was not a separation between the market separation between these populations, so that they had to stay separate forever. No, there was this. The same titles of these texts show pretty clearly how there was a clear acknowledgement of the necessity of regulating the whole society, right, and extending, yes, certain Germanic elements, institute certain laws specifically to the rest of the community. That surely was also in part, let's say, accepting the fact that this was the new rule, but because their society was also tendentially transforming towards that direction, in itself, as would happen elsewhere, just more slowly there, because the Roman rule, as we've seen, was more significant. I mean, the Romanization was more significant, but also for the same gods to start legiferating, to issue a written code, and in Latin, of course, both for the Germans and the Romans, and still drawing a consistent amount of stuff from the Theodosian Code, the post-Theodosian constitutions, Roman jurisprudence, and so on. So you understand an effort of, literally of control in society, of acquisition of certain power, recognized authority, capacity to dialogue, to have an impact on both communities, and to naturally also make the Germans realize that they needed themselves a fixed code that at that point was to be also probably to be used in order to discipline the nobility. That is to say, yes, this is our code, we have deliberated together, as far as the Germanic part concerned, for ourselves as conquerors and as freemen, but we have now to cope with the necessities of territorialization, which entailed the construction of a monarchy that for a while in the early Visigothic times was actually a hell of a monarchy, right? It functioned well, right? It up to a certain point had this peak of expansion of actual territorial control. Then it eventually would be eroded by the separate, the decentralization of the nobility and so on. But that had now to cope with the needs of a sedentarization never been seen before, as a need, as a function, right? All right, so we will naturally talk again about this because it's really fascinating, and we hinted here and there also. So we've actually, I think we made a video about the Ostrogothic law, or at least the permanence of the Justinian and of Roman law in Italy, if I'm not wrong, that included this, the presence of even these Visigothic influences on the, in Ostrogothic Italy and so on, or that sometimes we're actually more autochthonous, and however showing a similarity between the solutions that were found in these different lands. But for now, we stop it here. I just hope that you enjoyed this video. If you did, please share it. Otherwise, leave a like or subscribe to my channel if you're interested in my upcoming content. And for now, I thank you heartily for listening to me. I wish you a nice time and see you next time. Bye.